2.11 Checks on the judicial branch. So first, let's talk about judicial activism versus judicial restraint. So this whole judicial review thing has reserved the court the right to rule on government action when it violates a constitutional principle. And this includes the decisions of the executive branch and the legislative branch. And this seemingly places the Supreme Court above other branches. So, judicial activism, this is exercised when you strike down a law or reverse public policy, and it can be liberal or conservative depending on what this action is, done in the context of, or, the ideology that it follows. Activism, because you're acting, you're striking down something, you're reversing something, you're making a change, you're acting. And this power to strike down laws has encouraged litigation and changes in policy. And there's some examples in the book if you want help understanding that concept. Page 202 and 203. Anyway, critics of judicial activism advocate for judicial restraint. And they're like, the court shouldn't decide on a dispute unless there's concrete injury that will be helped or relieved by this decision. They're like, justices shouldn't declare a law unconstitutional when it doesn't mean what they want it to in a contemporary context, but only when it's clear that it contradicts the document. Basically, they are arguing for that strict constructionist point of view with the Constitution. It has to be very, very clear that it contradicts the Constitution and isn't constitutional without having to adapt it to a more modern context. They say that otherwise it's legislating from the bench. Other critics say that judicial policymaking is ineffective and undemocratic because most judges don't have this special expertise or strong support systems, and so their rulings aren't always practicable or practical for those who are meant to implement them. Interactions with other branches. Big idea. The U.S. Constitution establishes a system of checks and balances among branches of government and allocates power between federal and state governments. This system is based on the rule of law and the balance between majority rule and minority rights. So, presidential appointments and Senate confirmation. The Senate's Judiciary Committee will review the president's judicial appointments, and sometimes nominees are questioned, sometimes they're just confirmed. And a litmus test is this little determination of the appointees' sort of political philosophy and ideology and that sort of thing. So they'll ask these questions on controversial issues or look at their prior rulings from when they served on lower courts. And presidents, senators, etc., they can conduct these litmus tests. There's also this thing called senatorial courtesy. So senators recommend judges to the White House. And these individual senators have veto power over the nominees that are located within their state. So if I was a senator and the nominee came from my state, I would have veto power over them. So for U.S. District Court nominations, a senator is given a blue slip, and if they give it back, then they proceed. But if they say no and they don't give it, then it just stops and it's not going anywhere. And the hearing usually won't happen until both senators consent, and other senators tend to follow that home senator's lead on the issue. So the confirmation, so the president gets to nominate the justices. 36 have been not confirmed, and 11 have been rejected. The 36 not confirmed was the Senate never fully got to vote, or they pulled out, etc. Now, interest groups have also played a role because this sort of increasingly publicized confirmation process ends up involving these interest groups because it's become this sort of spectacle. For example, the American Bar Association has gotten involved and have kind of rated the nominees or given them a sort of grade. Then getting borked. This is a term because Bork was rejected, and he was very conservative, and they did not like him, and they really attacked him during the hearing session. They were attacking his character, background, and philosophy. So getting borked, or rather to bork, defined by the New York Times, according to the book, is to destroy a judicial nominee through a concerted attack on his character, background, and philosophy. Next, we're going to talk about Clarence Thomas. He reflected the left's desire for diversity and the right's desire for a strict constructionist. And when I talk left and right, I'm talking political ideology. People were concerned about how conservative he was, and people also questioned his experience. Anita Hill testified for accusations of sexual misconduct, and the Senate barely confirmed him. Now, the nuclear option, this is like the threat to filibuster. So basically, Bush's nominees took forever to go through this whole process, and Democrats took to filibustering, and so then you ended up with this threat to the filibuster because all Republicans needed was like a simple majority to disallow the filibuster. This was averted when a bipartisan group created a compromise, but this threat to the filibuster being able to be used, especially in these Senate confirmation hearings, that is known as the nuclear option. Denying Garland. So in 2016, there was a justice death, and Obama was a lame duck president, and there was a Republican Senate, so they kind of held off on the appointment. Obama nominated Garland, and there was a long vacancy of the seat, but then Trump won and nominated his own. That, obviously, the Republican Senate liked better. Executive and legislative influence on the court's power. So the other branches can obviously bring things to court. They can impeach and remove judges. They can use the power of the purse. They can redefine, partially redefine a court's jurisdiction and implement court rulings in their own way, like we were talking about the whole implementation thing earlier. The Department of Justice and the executive branch helps to investigate federal crimes. The U.S. attorneys there also prosecute accused criminals. The attorneys hold legal authority for federal civil law. The Solicitor General determines which cases to appeal to the U.S. Supreme Court and can represent the United States in the Supreme Court cases. Also, other branches can submit amicus curiae briefs, which is a friend of the court brief, and this argues for a particular ruling in which the U.S. is not a party. I think of this as amicus, amicable. Amicable means nice and friendly. So it's this little brief and here is what we think should happen, and we're as a friend to you, the court. Basically, in cases where the U.S. is not a party, they can give this little brief with their own opinion. And then impeachment. Federal judges can be impeached and removed. John Pickering was the first judge to be impeached. Thomas Jefferson's party then wanted to impeach another person, but Thomas was no, because we don't want impeaching to become a political tool. So his party wanted to impeach something, but then he was no, we shouldn't turn this into a political tool. Congressional oversight and influence. Congress sets and pays the salaries and budgets for courthouses. They pass laws that govern the judiciary branch and occasionally will create new seats in the district and appeals courts. Finally, defining jurisdiction. Article 3 gives the power to consider all cases arising under the Constitution, federal law or treaty, and admiralty or maritime jurisdiction. Basically, it talks about what jurisdiction is happening. What do certain courts have jurisdiction over, etc. Congress will periodically define and reshape the court's jurisdiction, and the legislature has the power to define what types of cases are heard by which courts, like federal or state courts. Congress can also define the types of parties that can go to various courts. And through this, they therefore define standing, which are the requirements to bring a case to court. Because while Congress can't create state courts, they can endow them with certain concurrent powers, basically allowing state courts to hear cases concerning federal law, certain cases. And sometimes Congress will do court stripping or jurisdiction stripping, basically when it wants to limit judicial branch's power in hearing cases. Basically saying, yeah, no, you guys can't hear a case about this. Thank you for watching. I hope this helped.